Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and today I will talk about the case of Life Insurance Corporation of India and another versus Sunita, wherein the Honorable Supreme Court discussed the importance of good faith in a contract of insurance. Before adverting any further, let us understand the plain meaning of insurance. It is defined as a contract by which one party undertakes to indemnify another party or the insured against risk of loss, damage, or liability arising from the occurrence of some specified contingency and usually to defend the insured or to pay for a defense regardless of whether the insured is ultimately found liable. In the same manner, life insurance is generally understood as an agreement between an insurance company and the policyholder to pay a specified amount to a designated beneficiary on the insured's death. Thus, I hope that the meaning of a contract of insurance is clear by now. Now, let us understand the meaning of good faith or bona fide or euberima fides. Good faith has been defined as a state of mind consisting in honesty in belief or purpose, faithfulness to one's duty or obligation, observance of reasonable commercial standards of fair dealing in a given trade or business, or absence of intent to defraud or to seek unconscionable advantage. Hence, in this context, let us understand the importance of good faith in a contract of insurance with the help of the observations by the court. Firstly, the court cited the case of Vikram Green Tech Limited versus New India Assurance Company Limited, wherein it was observed that an insurance contract is a species of commercial transactions and must be construed like any other contract to its own terms and by itself. In a contract of insurance, there is requirement of euberima fides, that is, good faith on the part of the insured. Except that, in other respects, there is no difference between a contract of insurance and any other contract. Secondly, the court laid down the four essentials of a contract of insurance as follows: A. The definition of the risk, B. The duration of the risk, C. The premium, D. The amount of insurance. According to the court, since upon issuance of the insurance policy, the insurer undertakes to indemnify the loss suffered by the insured on account of the risks covered by the insurance policy, its terms have to be strictly construed to determine the extent of liability of the insurer. And lastly, the court explained that the endeavor of the court must always be to interpret the words in which the contract is expressed by the parties. The court, while construing the terms of policy, is not expected to venture into extra liberalism that may result in rewriting the contract or substituting the terms which were not intended by the parties. The insured cannot claim anything more than what is covered by the insurance policy. Therefore, in light of the above stated enunciation of law, the court held that it is clear that the terms of the insurance policy have to be strictly construed, and it is not permissible to rewrite the contract while interpreting the terms of the policy. Those were the observations by the court. So, what are my concluding remarks? We see that a contract of insurance is not much different from a general contract. The only difference is that the interpretation of an insurance contract has to be made strictly, and liberal interpretation that adds or subtracts something in the contract that was not originally intended is impermissible. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.